Welcome back to LexTalks, legal topics simplified, where we, simplify legal topics.
We break them down.
Yeah, break them down, make them bite-sized.
Exactly.
And today's deep dive, this one's specifically for all of our listeners out there who are studying Indian law.
Aspiring lawyers.
Yeah, all those future legal eagles.
Oh, absolutely.
We're going to be tackling agreement to arbitrate in applicable laws.
It's a mouthful.
It is a mouthful, but trust me, it's a lot more interesting than it sounds.
Oh, yeah. Way more interesting than the title suggests.
Yeah. So to kind of set the stage, like imagine you're working on a contract, right? And you want to avoid those notoriously long court battles that we have here in India.
You and everybody else.
Right. So you want to avoid that
Yeah.
arbitration. That's often, the solution that people turn to.
That's right.
But it can get really tricky, right? When you start trying to navigate the maze of applicable laws.
Oh, absolutely. It can make a huge difference choosing the right laws and the right way to go about it.
Okay, so let's break down this maze.
Okay. So first things first, what exactly is an arbitration agreement? And why is it so important?
Especially in the Indian legal context.
Right. Yeah, exactly.
So an arbitration agreement is basically like a mini contract inside of your bigger contract. And it just spells out very clearly that if any disputes come up, you're not going to the traditional courts.
Gotcha.
You're going to go to a neutral third party who's called an arbitrator.
Okay, so it's kind of like instead of going to court and having a judge decide,
Right.
you have this independent expert
Weighing in. Yeah.
weighing in.
Yep.
Okay, and I'm guessing there are some perks to this, right?
Oh, there are big perks to choosing arbitration.
Right.
Like, you get a lot of flexibility.
Sure.
The parties can actually select an arbitrator who has, expertise in whatever the issue is.
Oh, interesting.
So that's a big advantage. And also, it's confidential.
Oh.
Which can be really important when you're dealing with, like, sensitive business matters.
Right.
Yeah.
So those are two big advantages right off the bat.
And I imagine it's also faster, potentially less expensive than going through, the Indian court system.
Absolutely.
I mean, nobody wants to be stuck in legal limbo for years and years and years.
No, that's the last thing anybody wants.
Right, exactly.
So, yeah, you can often get a much swifter resolution through arbitration.
Okay, so that all makes sense.
Good.
But you mentioned something about, like, legal layers to this whole process.
Yeah.
Can you kind of unpack that a little bit for us? What's that all about?
Okay, yeah. So there are actually three distinct legal frameworks that govern different aspects of arbitration. We call them layers, but they're really separate sets of rules, right?
Okay.
So the first one is called Lex Arbitri, and that just means the law of the arbitration, right? It governs the agreement itself.
Okay.
So Lex Arbitri is like, is this agreement even valid? Yeah. Is it enforceable? That's what Lex Arbitri tells you.
So even before you get to the actual meat of the dispute,
yeah,
you need to make sure that the agreement itself is actually legit.
Right, absolutely. You have to have a solid foundation. And so in India, if the agreement doesn't say where the arbitration is going to happen, then the courts, they use what we call the closest connection test.
Closest connection.
Yeah. So they look at things like where the contract was signed, where are the parties located, where did this whole thing happen?
So it's really important to pinpoint the where.
The where is key, yeah.
The where. Okay, so what about the what? Like, what law actually governs the substance of the dispute?
Right, that's a good question.
Like the actual,
the actual issue.
The issue, yeah,
So that's the second layer, and that's the substantive law.
Okay.
And that's the set of rules that, is used to actually decide the case, like who's right and who's wrong.
Okay.
And the good news is that the parties usually can choose which substantive law they want to apply.
Wait, so even if the arbitration is happening in India, they could choose, like, I don't know, French law?
They could, absolutely.
Wow.
That happens a lot, especially in international commercial arbitration.
Interesting. So it's not necessarily tied to the location.
Right.
Okay. And then what about the actual, like, how the arbitration unfolds?
Right.
So that's the third layer.
Yes, exactly. That's the procedural law.
Procedural law.
Yes. And that basically dictates, how does this whole thing work?
Okay.
How's the evidence presented? What are the deadlines? What's the whole process like?
So it's like the rule book for how the arbitration game is played.
Perfect. That's a great analogy.
Okay.
Yeah. And this procedural law, it's often tied to the seat of arbitration. So you could have, like, an arbitration that is seated in Singapore. but it's using Indian substantive law.
Okay.
But then the actual procedure would follow the Singaporean procedural rules.
Okay, so that's a lot to keep track of.
Yeah, it can be a little complicated.
I'm starting to see why understanding these different layers is really important.
Absolutely, especially in the Indian context.
Yeah.
Yeah.
All right, so we've got the basics down.
Right.
But let's get into some, key considerations when you're actually drafting an arbitration clause.
Yes.
And this is something that's really relevant for all those Indian law students out there, right?
Oh, this is bread and butter for them.
Yes, exactly.
Yeah.
So what about when you have a contract, but there are multiple parties involved?
Yes.
How does arbitration work in that kind of situation?
So the ideal scenario is that everybody's
on board.
Everybody's on board. Everybody's bound by the same arbitration agreement.
Right.
Because you don't want to have 3 different arbitrations going on at the same time.
Right.
It would be chaos.
Logistical nightmare.
Yes, exactly. A logistical nightmare.
And I'm guessing that happens a lot.
It does.
Especially when you're dealing with big business deals.
Oh, yeah. Complex transactions.
Yeah, exactly.
Lots of moving parts.
So how do you handle that then?
Clear drafting. Clear drafting is key.
Okay.
You want to spell out exactly how the arbitrators are going to be appointed when you've got, a whole bunch of parties at the table.
Are there any landmark Indian cases that kind of show how this works in real life?
Oh, yeah. There's a great one, P.R. Shah, Shares and Stockbrokers.
Okay.
And in that case, the Supreme Court actually allowed what we call concurrent hearings.
Okay.
So they were tackling issues arising from different contracts, if they were related contracts.
Right. So it's not always just everyone in one room, hammer it out kind of situation.
Sometimes it makes more sense to have, separate but coordinated arbitrations.
But it all comes down to how the agreement is written.
The agreement is ting, yeah.
Okay, gotcha.
Yeah.
All right, so we've talked about multiple parties under one contract. What happens if someone who wasn't initially part of the agreement gets pulled into the arbitration?
Okay.
Can that even happen in India?
So in domestic arbitration, if it's all happening within India, generally no. You can't force someone who didn't sign the original agreement to be part of the arbitration.
That makes sense. You can't just force someone into something that they never agreed to.
Right, exactly.
Yeah.
But things get a little trickier when you start talking about international arbitration.
Oh, okay.
There's a case called Chloro Controls India PLTD.
Okay.
And that kind of highlighted that in international commercial arbitration, sometimes you can pull in third parties.
Oh, wow.
Even if they weren't, originally part of the agreement.
Okay, so it really depends on whether it's a domestic case or an international case.
It does, yeah. It highlights why understanding all those nuances of the Indian legal system is so important.
Exactly. Okay, so I have a question.
Yeah.
Are all disputes fair game for arbitration in India?
That's a good question.
Or are there some things that are, off limits?
You're right. It's not a simple yes. There are definitely some matters that are considered non-arbitrable.
Okay.
So typically things like criminal offenses, family matters.
Right.
Those are usually reserved for the traditional court system.
Okay.
It wouldn't be appropriate to have those, decided by a private arbitrator.
Right, exactly.
The general principle is that rights in personam, which means rights that are between specific parties, those are arbitrable.
Right.
But rights in rem, which are rights that affect everybody in general, those are usually not.
That makes sense.
You can't have a private arbitrator deciding on a matter of public law that affects the entire country.
Right, exactly.
And there's a case called Booz Allen and Hamilton, Inc. that really kind of gets into that whole distinction.
Okay.
And it shows how the courts will carefully examine a dispute to see if it's something that can actually be settled through arbitration.
Okay, so there are definitely some limits.
There are, yeah.
But even when something is arbitrable, who gets to decide what?
Ah, good question.
What's within the scope of the arbitration?
Yeah.
Who makes that call?
So that's where this principle called competence comes into play.
Competence. That sounds very...
It's German.
German, yes.
Very German. But it's a key concept in international arbitration.
Okay, let's unpack this. What does it mean?
So it basically translates to competence about competence. meaning that the arbitral tribunal, so that's either a single arbitrator or a panel of arbitrators, they have the power to decide on their own jurisdiction.
Okay, so they get to decide if they're even allowed to hear the case.
Exactly. They get to decide if they have the authority.
Okay.
So it's like a referee in a football game deciding if a play was, within the rules.
Okay, that makes sense.
Of course, there are limits. So the Indian courts, they can intervene on what we call pre-reference issues.
Okay.
Like, is the arbitration agreement even valid in the first place?
Right.
But once that tribunal is formed, they have a lot of power to shape, the scope of their authority.
So they're not just passively applying the rules.
No.
They're kind of actively defining, like, their role in the case.
Exactly, yeah. They have a much more active role.
Okay. And are there any Indian cases that kind of illustrate this principle?
Yeah, there's a good one. It's called Patel Engineering and Bogara Polyfab Private Limited. Okay. And that case shows that even if there are, serious allegations like of illegality or fraud, within a contract, the tribunal gets to decide on that first.
Wow.
Not the courts.
Okay, so that's a lot of power.
Yeah, it's a lot of responsibility too.
Yeah.
But it really underscores how important it is to understand how this whole process works.
Right, exactly.
Yeah.
Okay, so even though Indian courts, they kind of play a supporting role, the tribunal really holds a lot of sway in shaping how the arbitration unfolds.
Right, they're the ones driving the bus, so to speak.
Yeah, exactly. Yeah. This competence thing, it really highlights how much authority the tribunal has.
Yeah, it's a big deal.
But, I mean, does this mean that, like, Indian courts are totally out of the picture in arbitration cases?
No, not at all. I mean, the tribunal definitely plays a central role, but there are absolutely situations where you might need the Indian courts to step in.
Okay.
Even when there's a valid arbitration agreement in place.
Yeah, I can imagine there were times when you just need the court to kind of,
keep things fair.
Keep things fair, yeah.
Yeah.
So, like, what are some examples of that?
So let's say one party tries to ignore the arbitration agreement. And they go and file a lawsuit in court.
Right.
The other party can actually go to the court and say, hey, wait a minute.
Yeah.
We agreed to handle this through arbitration.
Right, exactly.
So you need to stop this lawsuit and enforce the arbitration clause.
It's like, remember, we had a deal.
Exactly. We had a deal.
Okay.
Another example is when a party needs to protect their assets
before
the arbitration even begins.
Okay.
So imagine a company that's worried the other party might try to, sell off assets or move funds around to avoid paying.
Right, to avoid paying the award.
Exactly.
Yeah.
So they can ask the Indian court to freeze those assets as a safeguard.
So it's kind of like, a legal timeout before the, the main event.
Yeah, exactly, to prevent any funny business before the arbitration actually starts.
Right.
You also might need the courts to step in for procedural reasons.
Okay.
So let's say the arbitrator who was appointed can't continue, maybe there's a conflict of interest or something unforeseen happened. You'd have to go to the court and ask them to appoint a new arbitrator so the process can keep moving forward.
So the courts are kind of like a safety net, right?
Yeah. That's a good way to put it.
To make sure that the arbitration process actually runs smoothly.
Exactly. They're there to support the process, not undermine it.
Right.
They're guardians, basically, stepping in to make sure everything's fair.
Okay, so that all makes sense. We've mainly been talking about arbitration that happens within India.
Right.
What about if you have an arbitration award that was granted in another country?
Okay.
And you need to enforce it here in India?
Yeah, so that's a little bit different. But India actually has a system in place to handle that.
Okay.
So enforcing foreign arbitration awards in India falls under Part 2 of the Indian Arbitration and Conciliation Act.
Okay, so there's like a whole section of the law dedicated to this issue.
Yeah, exactly.
Okay.
And a really key element here is something called the New York Convention.
New York Convention.
So it's an international treaty, and it basically makes it easier to enforce arbitration awards across borders.
Okay.
So India has signed this convention, which means that, generally speaking, awards from other countries that are also part of this convention, they're recognized here in India.
Oh, okay. So it's kind of like it's giving those awards like some teeth.
Exactly. It gives them legal weight. even if they were issued in another country.
Okay.
But even with the New York Convention, there can be some roadblocks.
Okay.
One party might say, hey, I wasn't even told about the arbitration, or that award, it goes way beyond what we agreed to.
Okay.
So there are definitely safeguards in place.
Yeah, to make sure that,
Right, to make sure things are fair.
That everything's legit.
Right.
What about if enforcing a foreign award would clash with Indian law or public policy?
Ah, yes, that's a big one.
Yeah.
That can definitely be grounds for refusal under the New York Convention. So, for example, let's say a foreign award allowed something that's illegal in India.
Yeah.
That wouldn't be enforced.
Right.
Like, imagine a scenario where a foreign award allowed, I don't know, the sale of something that's prohibited in India.
Right. Yeah.
That would clearly violate Indian public policy, and a court would likely refuse to enforce it.
Okay, that's a good example. So even though these international conventions exist, ultimately the Indian courts have the final say.
Right. They have to balance, upholding international agreements with protecting India's own interests.
Right. Right. It's a balancing act.
It is, yeah.
Okay. We've covered a lot of ground today.
Yeah.
I think it's pretty clear that this whole world of arbitration agreements and applicable laws,
it's a lot.
It's a lot.
It's full of intricacies, yeah.
Yeah, it's complicated stuff.
Definitely requires attention to detail, especially in India.
Yeah, and especially, India's legal landscape is constantly changing and evolving.
It is, yeah.
So we've been talking about, the practical stuff.
Right.
But there's also a strategic side to all this, right?
Absolutely.
Like how do you actually use this knowledge to your advantage?
Yes. And this is something that, all the future lawyers out there need to keep in mind. Choosing the right jurisdiction, the right law, the right procedural rules.
Right.
It can make a huge impact on the outcome of a case.
It's almost like a game of chess.
Right? It is, yeah.
You have to be thinking several moves ahead.
Exactly.
Like, what are the potential challenges? What are the potential benefits?
Right. You have to anticipate those things.
Right.
Based on the legal framework you choose.
Okay. So let's say you're advising a client.
Okay.
Who's about to do a big international deal.
Yeah.
You wouldn't just automatically say, okay, let's have the arbitration in India.
Right.
Right.
You'd want to explore other options.
Yeah.
Look at different arbitration systems,
Right.
See how easy it is to enforce awards in different countries. Weigh the pros and cons of different legal systems.
So it's not just about knowing the law. It's about knowing how to use it strategically.
Exactly. That's the key.
Okay. Gotcha. So, for example, if your client's dealing with someone from, a completely different legal system, you might advise them to choose a neutral jurisdiction.
Yeah, a place where both sides feel like they'll get a fair hearing.
Right. So instead of just defaulting to India, because that's where your client's based, you might recommend, I don't know, Singapore or London.
Absolutely.
As the seat of arbitration.
Exactly. Or if the dispute involves a really specialized area of law, like let's say intellectual property, you might want to go to a jurisdiction that's known for its expertise in that area.
Okay.
Even if that means going a little further afield.
So it's this whole, balancing act between what's familiar and what might be, the best legal landscape.
Exactly. Finding the most advantageous system for your client.
Right. Okay. That makes a lot of sense.
Good.
Wow. It's really interesting how all these pieces kind of fit together.
Yeah. It's a puzzle.
Yeah, it is a puzzle.
But it's a fun puzzle.
It sounds like a very, challenging area of law.
Challenging, but definitely rewarding.
Yeah.
Yeah, it's at the forefront of international business. And it demands, really sharp legal minds and creative problem-solving skills.
Well, I think we've given our listeners a lot to think about today.
I hope so.
We've gone through, the different layers of the legal framework, the nuances of drafting these clauses.
Yeah.
And even, touched on some of those strategic considerations.
Yeah, just scratch the surface, really.
Yeah, exactly. Exactly. It's a very complex topic.
It is.
But I think, we've
given them a taste.
Yeah, we've given them a taste of,
of what's involved.
Exactly.
Yeah.
It's fascinating how many nuances there are.
Oh, yeah. Tons of nuances.
To consider with all this stuff.
Absolutely, especially in India.
Yeah.
It's a dynamic legal environment.
Exactly.
Yeah.
So for all of our listeners out there, especially those aspiring lawyers, remember, mastering the legal framework.
It's just the beginning.
It's just the beginning.
Yeah.
You also need to develop your strategic thinking.
Right.
Your client management skills.
Right.
That's going to be so important to your success.
Absolutely.
In this field.
Yeah. It's more than just knowing the law.
Right. Exactly. It's about how to use it.
It's about how to apply it. Yeah.
Yeah. All right. Yeah, it sounds like arbitration's a lot more dynamic.
Than people think.
Yeah.
Than people think.
It's constantly evolving, especially as we have more and more like global commerce and these cross-border transactions.
Yeah, more and more common.
Yeah, it's becoming the norm. And that's why it's so important, for Indian law students. Especially, yeah, to really understand this stuff. Right. I mean, India is becoming a major hub for international business.
Yeah, absolutely.
And arbitration is like the way to resolve disputes.
Yeah, in this globalized world, that's what people are turning to.
Exactly. So let's go back to that idea of strategy. We talked about the legal stuff, all the, the ins and outs of the law.
They're nuts and bolts.
Yeah, the nuts and bolts.
Yep.
But let's say you're sitting across from a client.
Okay.
And they're about to do a big international deal.
Big deal, yeah.
What kind of things, like beyond just the law, would you be thinking about when you're advising them on how to put together that arbitration clause?
Well, you really need to get inside your client's head, right?
Okay.
Understand their goals. What are they hoping to get out of this whole thing?
Okay.
Are they looking for a quick resolution?
Yeah.
Or are they prepared for a long fight?
Right.
Are they worried about confidentiality? Are there certain cultural things you need to be aware of? You have to kind of like put all those pieces together.
So it's almost like a doctor, right?
Yeah.
Like diagnosing a patient.
Exactly.
You got to gather all that information before you can give them the treatment plan.
I love that analogy.
Okay, gotcha.
Yeah. So once you understand your client's needs, then you can start looking at, different countries, different legal systems.
Yeah.
Some countries are really, pro-arbitration.
Yeah.
They've got streamlined procedures.
Right.
Other countries have expertise in certain industries.
Right.
And then, of course, the cost can vary a lot.
Right.
Depending on where you go.
Yeah. So, like, if it's an intellectual property dispute, you might choose a country that's, really well known.
Yeah, that's a good example.
For that kind of expertise.
Exactly. Or you might choose a country that's, really good at enforcing awards.
Right.
If that's what your client's really worried about.
Right.
Making sure they can actually collect if they win.
Right, yeah. If they win, that they actually get what they're owed.
Exactly.
It's amazing, like, how much goes into all this.
It's a lot, yeah.
It really is like a balancing act.
It is.
Between what's familiar, what's best for your client, the legal landscape.
Right, and it requires, a deep understanding of how this whole system works.
Yeah, and how it's all changing.
Yeah, constantly changing. Global commerce is not slowing down.
Right, exactly. So it sounds like a really fascinating area of law.
It is.
But also very challenging.
It is. But that's, that's what makes it fun, right?
Yeah, I bet.
Yeah. It's really at the cutting edge of international business.
Yeah.
So it requires, sharp minds, problem-solving skills.
All right. Well, I think we've given our listeners a lot to ponder today.
Hopefully.
I know I've learned a lot.
Good.
We've gone through, like, the different frameworks that govern all this stuff.
We did, yeah.
The nuances of drafting the clauses.
Yeah.
And even, touched upon those strategic considerations.
The big picture, yeah.
Yeah, the big picture, exactly.
It was great exploring all these concepts with you.
Yeah. It's been a great conversation.
Hopefully we inspired some future lawyers out there, Got them thinking about arbitration.
I think so, yeah.
Okay, good.
All right, so thank you to everyone for joining us on LexTalks.
Yes, thank you.
Hopefully this deep dive gave you some insights into this whole world of arbitration.
Fascinating world.
Yeah, very fascinating.
Yeah.
And for all you Indian law students out there, like, we just scratched the surface.
Oh, yeah, tip of the iceberg.
There's so much more to learn.
Tons to explore.
So be sure to subscribe.
Stay tuned.
And stay tuned for more of these deep dives coming your way.
More legal fun to come.
Exactly.